Lecture: Government by Constitution.
The year 1987 marked the 200th anniversary of the U.S. Constitution. For over 225 years, it has provided the basis for a stable government and has remained basically unchanged. We all know that the United States is a relatively young country. The interesting thing to note, however, is that the U.S. Constitution is actually the oldest written constitution in continuous use in the world. Today, we will try to understand the U.S. government better by looking at two important principles provided by the Constitution. These two principles, so important to understanding the U.S. government, were written into the Constitution over 225 years ago and are still in effect today. These two principles are: 1. The separation or division of powers, and 2. A system of checks and balances. Before we begin our discussion of these two principles, let's first take a look at the three branches that make up the U.S. government. To start, the Constitution provides for three branches of government. These three branches are: 1. The legislative, 2. The executive, and 3. The judicial. First, the legislative branch, which is the Congress of the United States. The Congress is primarily responsible for enacting or making new laws that are to be followed by the 50 states of the country. Second, the executive branch, which is headed by the president and includes the vice president and the president's cabinet, the members of which he appoints. The executive branch executes the laws that originate in the legislature. By signing the laws, the president actually puts the laws into effect. After the president has signed a new law, the executive branch of the government is responsible for seeing that the new law is enforced or carried out. Well, these are the first two branches, so we're ready to discuss the third branch. Do you recall what the third branch is? You're right if you said the judicial branch. Well, the judicial branch is responsible for trials and court cases involving individuals or corporations that are accused of breaking a federal law. The judicial branch decides any kind of legal issue that falls under federal jurisdiction. A very important responsibility of the judicial branch is to review cases where someone believes a law may be unconstitutional. In other words, the judicial branch can judge if a particular law is legal using the Constitution. From this, you'll already have an idea of what is meant by separation of powers. Each branch of the government has its specific role in relation to the country's laws. That is, each branch has its own particular power that is not shared with the other two branches. The writers of the Constitution established this separation of powers to make sure that no single branch of the government could ever have all the power. In addition, to make sure that no single branch could abuse its power or become more powerful than the other two branches, a system of checks and balances was written into the Constitution. This system of checks and balances gives each branch of the government a specific way to check or limit in some way the acts of each of the other branches. The best way to understand this system of checks and balances might be to discuss a few examples of how it works. First, let's consider how the executive branch can check the power of the legislative branch. The most obvious example is the presidential power of veto. Suppose the president feels that a law enacted by Congress is unwise. A president who feels very strongly that a new law is wrong may refuse to sign it. Now, Congress can override a presidential veto, but it is a very difficult thing to do. So a presidential veto may put an end to this new law forever. Now let's look at an example of how the legislative branch, or Congress, can check the power of the executive branch. Many of you may have heard of the Watergate scandal, which took place in Washington, D.C. in 1973. In the Watergate affair, President Richard Nixon and his staff were suspected of covering up their involvement with illegal activities. In such a case, where someone in the executive branch is suspected of illegal or unconstitutional activities, the legislative branch is given power by the Constitution to investigate. If the investigation shows that illegal activities probably did take place, Congress has the power to impeach or charge the person. A trial could then be held in the Senate to remove that person from office. This, in fact, did not happen to President Nixon because he resigned before the House of Representatives was able to vote on the articles of impeachment that were already approved by a House committee. For another example of checks and balances, let's look at the judicial branch. The U.S. Supreme Court, the highest court in the judicial branch, hears cases involving the constitutionality of federal laws enacted by Congress. For example, in 2012, the court heard arguments that challenged parts of a controversial healthcare bill. This is a bill that was narrowly passed by the legislature, that is, Congress, only after a huge political struggle. It was signed into law by the President Obama. In this case, the court found that most of the provisions of the bill were constitutional. You might wonder what check the executive or the legislative branch has on the judicial branch. Well, first of all, the president is the person who nominates candidates to be federal judges, including those on the Supreme Court. Because there are only 9 Supreme Court justices, the opportunity to nominate even one candidate for the Supreme Court can be an opportunity to change the balance of power on the court itself. However, once the president nominates a candidate, the Senate must approve the choice. This provides the legislative branch a check on both the executive and judicial branches. Any candidate who is nominated for the Supreme Court by the president can expect to be questioned very closely by members of the Senate. They will ask questions about his or her legal record and opinion on such issues as abortion, gun control, separation of church and state, and so on. Most people who are nominated for the Supreme Court by the president are confirmed. That is, they are approved by the Senate, but not all. Under the Constitution, each branch of the government, then, must answer to the other 2 branches. Therefore, ideally, no one branch can exercise too much power or abuse the power that it has. From time to time,